Permettez-moi de remercier l'organisateur pour l'opportunité de participer à cet intéressant colloque. Merci aussi pour votre accueil. Désolée, je ne parle pas français, so I switch to English in order to deliver the first part of our presentation, focused on the conflict between courts on the primacy of EU law over national provision, especially with regard to the rule of law crisis scenario. It has been already mentioned that the communities that gave rise to the integration process were conceived and built as a sort of antidote against nationalist tendencies, the persistence of which would have constituted a constant threat to peace. In this, it echoes Luigi Einaudi's thought in his July 1947 speech before the Italian Constituent Assembly. Einaudi identified the myth of absolute national sovereignty as the #1 enemy of civilization and of prosperity. However, over these 2 days, we are arguing about conflicts persisting within the European Union itself, due to being a union of sovereign states, bearers of their own legal orders, tending to integration into a new legal order. We might say that from the need to mitigate conflicts of law, antinomies, the elaboration of some principles that have gone to connote EU law, as the reason I'm referring to the direct effect and the primacy. In fact, the former can be rightly considered as an enforcement tool, additional, of course, to mechanisms explicitly laid down in the treaties, such as the infringement procedure, against the first manifestations of systematic opposition of the governments regarding the loyal execution of their obligations. Furthermore, the primacy of EU law provisions having direct effect satisfies the essential requirement to ensure the common legal order, preventing it from being jeopardized by unilateral act of will of the individual member states. Although not codified in the treaties, but well established in the settled case law of the Court of Justice of the European Union, nevertheless, this guarantee represents a cornerstone principle of EU law. Mentioned in Declaration number 17, it is qualified as a fundamental principle of European Union law, inherent to the specific nature of the EU itself. But principles might be read as manifestation of a more general principle of effectiveness, a sort of meta principle, which also represents the pivot of the legal reasoning of the Court of Justice of the European Union in carrying out its task pursuant to Article 19 TEU to ensure compliance with the law in interpretation and application of the treaties, as supported by the basic objective of maintaining the operation of the system itself and its ability to function effectively in the pursuit of its own purposes and in the protection of its values and interests. In other words, the primacy of European Union law is affirmed over any type of national provision, including both fundamental rights as formulated by the Constitution of a member state and the principles of a national constitutional structure. And in a case of conflict, the validity of EU measure or its effect within a member state is not affected. What does it mean? It does mean that a member state's reliance on rules of national law, even of a constitutional order, cannot undermine the unity and the effectiveness of EU law, precisely for the sake of the settled case law, according to which the principle of the primacy of EU law is binding on all the bodies of a member state, without in particular any provisions of domestic law relating to the attribution of jurisdiction, including constitutional provisions being able to prevent that. The extent of the primacy of EU law is also developed through the productive dialogue. We are going to call it logoi, using the Greek wording, between the Court of Justice of the European Union and the constitutional justice bodies of some member states. Consider, for example, the Italian Constitutional Court in the context of openness to a system other than the national one. It has identified the existence of external limits, so-called counter limits, which are based on the need to ensure respect for the essential content of the supreme principles of the constitutional legal order. Which are they? In practice, they are those principles that cannot be countered or modified in their essential content, even by constitutional revision laws or other constitutional laws. Actually, these have never been formally activated. Rather, the mere prospect of the counter limits has underpinned the logoi between courts and, as for example, in the Taricco saga. Therefore, while reiterating that Article 325 TFEU imposes on the member state precise result obligations, which entail the consequences application of the internal rules conflicting with it, the Court of Justice has emphasized the principle of determination and predictability of applicable law as belonging to a heritage of shared values, enshrined in Article 49 of the Charter of Fundamental Rights, and only the latter is able to act as a limit to the concrete application of EU treaty. This kind of judicial dialogue may substantially serve national courts as a means of urging the Court of Justice to reconsider its previous findings. I cannot go any deeper, thus I just highlighted that in the aftermath of a new judicial sovereignty season, the same Italian Constitutional Court has recently, March 2022, recognized the principle of primacy and Article 4, Paragraph 2 and 3 TU as the cornerstone on which the community of national courts rests, held together by convergent rights and duties. Underline that within this system, the centralized review of constitutionality enshrined in Article 134 of our Constitution is not an alternative to the widespread mechanism for implementing European law, but rather merges with them to build an increasingly well-integrated system of protection. However, some other constitutional courts have more strongly questioned the absolute nature of primacy after the Lisbon Treaty, also through the increased reference to the new worded identity clause under Article 4. We might consider the German Federal Constitutional Court in the wake of the famous Maastricht, Solange cases. The latter has opposed the Court of Justice and the European Central Bank with a lack of motivation regarding the proportionality of the monetary policy measures adopted with the PSPP, and therefore the ultra vires action with respect to the spheres of competence attributed to them by the treaties. Actually, the General Federal Constitutional Court openly challenged the Court of Justice primacy as the ultimate arbiter over EU law. However, once the European Commission has opened an infringement procedure, this has been closed due to German government's strong commitments about the principles of autonomy, primacy, contiguous, and uniform application of European law, as well as the values laid down in Article 2. Unlike this case, the genuine denial of the primacy of EU law lies in the action of the Polish Constitutional Tribunal by affirming the primacy of Polish law over EU law. The 7th of October 2021 judgment ends up undermining the core of European Union law, placing itself in a completely subversive way with respect to the European legal order. In one of our papers, we have qualified this construction as primacy à rebois, highlighting the ultimate purpose of contrasting the complaints relating to the reforms of the Polish judicial system raised by the Court of Luxembourg. It led the Polish Constitutional Tribunal to a generalized affirmation of the primacy of the national fundamental law, characterized by the disavowal of the principles and values on which the process of European integration is based, especially of that pivotal principle, the primacy, inherent to the specific nature of EU itself, and which has its own foundation in the voluntary acceptance of the obligation deriving from the treaties to which the member states have acceded. It is also singular that, unlike the traditional scenarios of activation of constitutional counter limits, the Polish judgment does not originate from a specific dispute pending before a national jurisdiction. While it is the Prime Minister who raises an appeal concerning issues considered to be systematic and of fundamental importance for the functioning of the constitutional bodies of public power of the Republic of Poland. A substantially preordinated recurs to structurally review the foundations of European integration process, despite adherence to the values and principles that characterize this organization. Within this crisis of values scenario, dominated by the soy logoi, using the Greek wording once again, a process of attraction has been activated, a domino effect. And we might say that it has been triggering in a twofold direction, within the Polish legal system and within other legal systems. In the first direction, I just mentioned the conclusion reached by the Polish Constitutional Court could be further reaffirmed and strengthened, considering some pending cases where conflict to Court of Justice and TU judgments was announced. In order to explore the second direction, to address some conclusion, I leave the floor to my colleague, Angela Festa.
Merci. Merci beaucoup à tous les organisateurs pour l'opportunité de participer à cet important colloque et pour l'accueil chaleureux reçu. Je ne parle pas français, je m'excuse et je vais donc continuer les discours en anglais. In my brief remarks, I would like to focus on some aspects of the Hungarian and the Romanian cases, which are quite different from the Polish one, but still not unproblematic. Indeed, even though we do not have a clear break as the one operated by sentence number K31, where the Polish Constitutional Tribunal found a conflict between the Polish Constitution and some founding values and principles of EU law, affirming the supremacy of national law and denying that of the EU, we do have conflicts around the primacy also in the Hungarian and the Romanian case. In our view, the Hungarian case could be read as an example of neutralization of the conflict, while in the Romanian case, we do have a sort of mitigation of the conflict. I shall try to be clearer in 1 minute. Well, it's known that the correct application and the uniform interpretation of EU law are granted even through the mechanism of the preliminary ruling, which enables a direct dialogue between the Court of Justice and the national courts. And this dialogue cannot be precluded. In this context, attention must be drawn to the Hungarian case, since in that legal order, a decision making a reference for a preliminary ruling can be appealed in the interest of the law and eventually declared unlawful by the Supreme Court, which is called Curia. Furthermore, according to Curia, to the Curia settled case law, a request for a preliminary ruling should not be submitted in order to obtain a declaration that the applicable Hungarian law is inconsistent with fundamental principles protected by EU law. So when the Central District Court of Pest in 2019 raised a request for a preliminary ruling aimed to assess the conformity of Hungarian law with the guarantees on a fair trial and the principle of the independence of judges, the Hungarian Curia declared the illegitimacy of the request. And by declaring the unlawfulness of the preliminary questions, we argue that the Supreme Court has neutralized the conflict, has interfered with the direct dialogue between the national judge and the Court of Justice, and as a consequence, has diffused the primacy of EU law. Furthermore, if one may consider that for the same reasons on which Curia's decision was based, disciplinary proceedings were initiated against the same referring court, it follows that this jurisprudence is also capable to produce a chilling effect on other judges with regard to the presentation of requests for preliminary rulings. However, despite the intervention of the Supreme Court, in that specific case, the referring judge persevered in dialogue with the Court of Justice and posed additional questions which aimed to assess the compatibility of the same decision taken by Curia with Article 267 TFEU, and to ascertain whether the principle of judicial independence is violated when disciplinary proceedings are initiated against the judge by reason of a request of a preliminary ruling. And in the judgment IS of the 23rd of November 2021, the capability of the Hungarian system to alter the preliminary reference mechanism and the primacy of EU law is clearly highlighted. According to the court, the legitimacy check carried out by the Hungarian Supreme Court for its own reasons can risk undermining the effectiveness of EU law. In this way, the curious attempt to neutralize the conflict and the primacy of EU law is opposed by the Court of Justice in the light of the primacy of EU law itself. Another example of conflict around the principle of primacy can be read in the position taken on the 23rd of December 2021 by the Romanian Constitutional Court, which, by means of a press release, recalled the binding nature of its decisions and declared that the Court of Justice judgment delivered 2 days earlier on the primacy of EU law, the famous Eurobox promotion case, could not be implemented without amending the Romanian constitution. In other words, the Curtea Constituțională, in order to defeat the decision of the Luxembourg Court, argued that the application of the European jurisprudence must pass through a reform of the Romanian constitution, which cannot be carried out ex officio, but needs in any case of an initiative to be taken by the subject appointed to do so in the forms established by the constitution. The position of the Bucharest judge, although supported by a press release and therefore a non-legally binding act, is in any case of particular importance, because in re ipsa, it is capable of interfering with the judicial activity of common judges and exercising on them the already mentioned chilling effect with respect to the application of European law, even considering that in Romania, judges are liable to disciplinary actions if they fail to implement the judgments of the Constitutional Court. Moreover, the Romanian Constitutional Court position has to be considered carefully also because it is not unique. A similar conclusion had been formulated by the same court, and this time with sentence, on the 8th of June 2021, when it was affirmed that national judges cannot review the validity of internal rules in terms of compatibility with EU law, where such rules have already been deemed to comply with the Constitution by the Constitutional Court. So by affirming that any law declared legitimate acquires constitutional value and consequently higher authority over EU law, we argue that the Romanian High Court is mitigating the primacy of EU law, since it's denying the application of the principle for national acts that have passed the test of legitimacy. But once again, the National Court attempt to mitigate the conflict is opposed by the Court of Justice in the light of the primacy of law itself. As stated on February in the case RS, by virtue of the principle of primacy, national courts must be able to examine the conformity of national provisions with EU law, regardless of whether they have been held constitutional by a decision of the National Constitutional Court. So, if it's the general picture, the consequences of the conflict are even less clear. And further, it nourishes the question about the future scenarios and the reactions to be undertaken, considering that the primacy saga fits into a more generalized rule of law crisis. As regard to the Romanian case, we can say that steps were taken to address these concerns at national level, and the High Court of Cassation gave several judgments setting aside the case law of the Constitutional Court to give effect to the judgments of the Court of Justice. In the Polish case, instead, the fracture is more clear-cut, but the Russian aggression against Ukraine has led to a changing landscape in the primacy saga. And it seems almost that the conflict has neutralized the internal conflict one. In fact, the Commission, as we have already mentioned yesterday, had not addressed Poland over rule of law concerns with the new instrument, Regulation number 2020-2092, like it did in April with Hungary. And in June, the Commission also approved the Polish recovery plan, despite rule of law concerns. Certainly, in the primacy challenge, the work of the court of the Court of Justice is crucial and is remarkable. And we can also say that the Court of Justice is working not only through the strict judicial activity. The court is opening up more and more to the outside and is promoting informal dialogues with the high courts. In a meeting with the Italian Constitutional Court at the end of September, it also emerged the need to strengthen horizontal cooperation networks between the courts of the member states. And in our view, it could be a useful tool to recompose the conflict and bring it back to those productive dialogues or logoi based on good faith and mutual respect. Is that enough? Of course, in a face of structural conflicts, the judicial path cannot be the only one. We are aware of the need to contain the crisis also from a political point of view, and apart from the necessity to conclude the procedure of Article 7, paragraph 1, which is ran aground before the Council, it requires working on alternative political solutions that can ensure the integrity of the European project. But we will hear about this in the next intervention. Thank you very much for your attention.